Thank you. All right, you're Derica Johnson. And Ms. Johnson was previously in court, entered pleas of true in a motion to revoke probation to counts 1 through 4. On probation for aggravated assault causing serious bodily injury, and that was a 6-year deferred probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And there was no agreement, correct? I'd agree. Also, just for everyone, and if we can get copies if you guys need it, I am also reviewing jail incident reports as well. Mr. Rojas, you may proceed.
Judge, as the court knows, this is Ms. Johnson's third motion to revoke. She's been given opportunities in the past to comply with ISF, MRT, and some mental health counseling. She hasn't taken advantage of all those opportunities. She has some CPS cases going on. She's kind of doing double load casework. She's got some CPS cases in Harris County. She's taking some classes through there, and that had been her focus up to now, is trying to get her kids back. I've discussed this current motion with her. She understands that the options the court has this morning are to go to probation, send her to prison, or to try one more time and get her some help through either ISF or SafeP. In discussions with Ms. Johnson this morning, I think the option that she would rather do is to ask the court for some mercy and give her the lowest amount of time in prison possible. We would request something in the neighborhood of 2 to 4 years. She, at this point, doesn't feel that she needs a drug treatment, and the ISF program is this thing that, well, she was removed last time because she's pregnant. She's not pregnant right now, so I think this would be the perfect time for her to go to ISF and get that help. But she tells me that she doesn't want that. She would just rather go to prison and get this case over with.
Ms. Malfino?
Judge, I concur with Ms. Lopez's updated PSI. It's very thorough and goes through every opportunity this individual has been given by the court. It's a shame she doesn't want the help. Really could help her. I mean, if she was using last time while she was pregnant, she's obviously somebody who has an issue that needs to be addressed. But she doesn't want the help. I guess she shouldn't take up someone else who wants the help spot. And so I think revocation is appropriate with something in at least in the mid-range.
Give me just let me look real quick. I got the, let me see what this.
Looks like she had one prior MTRP and was given 120 days sanction at that time in 2023.
I mean,
the facts of the underlying case, I think she threw a bottle at a girl and waved a knife at another. We pled on dismissed from originally. I think nobody was injured, judges, just threats basically.
well, she threw the bottle attempting to hit someone else, but it hit someone, but it hit someone else in the head. Well, there's no accidentally. You meant to hit somebody with it. You just hit the wrong person. Right? No, because Ms. Johnson, you have been coming here now way too long and been given every single opportunity to stop talking over me. Because right now, what you're looking at that I can do is give you between 2 and 20 years in prison. And the more you talk over me and are disrespectful, the higher number that's going to get. Do you understand? You have been, I'm not even sure how many times now that you've been in here pregnant, using drugs while you're pregnant, while we're trying to get you help. You have 5 kids that you have no custody of. It's the jail incident reports are ridiculous. And then you want to come in and say, I just want to get this over with. Give me a couple years in prison, which you probably have credit for it, which is absolutely not what I'm going to do. Give me just a second. The fact that this is kind of your 4th shot at it makes me wonder what I was thinking the prior 3 times. And really, All right, Ms. Johnson, this time I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit for any time that you've been in custody that the law gives you the right to receive. Am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you the trial court certification, the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Good luck to you. You can go back with the bailiff. Good morning, sir. You Brian, is it Barrier? And Mr. Barrier was previously in court, entered a plea of guilty to the third-degree felony offense of placing a serial number with intent to change the identity. I've received that pre-sentence report and reviewed it. Have you all had an opportunity to review that?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
No, Your Honor.
Not from the state judge.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made and find you guilty of placing a serial number with intent to change identity. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections, but that will be suspended. You'll be placed on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 3-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that 3-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Smith. All right, good luck to you, sir. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck. And then you've got Cedric Franklin sentencing, Mr. Smith.
Yes, Your Honor.
Good morning, sir. Are you Cedric Franklin?
Morning, fine.
And Mr. Franklin, before I go forward with